Hello, I'm Nick Hobden, head of the employment team at Thompson and Passmore, and I've been reading about a recent case of a cleaner, Mrs. Ogamadede, who was employed by Churchill Contract Services and who was dismissed for having two jobs. Now, it seems to me that a number of people have more than one job, so on the face of it, this doesn't seem like a fair dismissal. So, with that thought, I'm joined by Ben Stepney, a partner in the team. And Ben, I'm going to ask you to shed some light on that case, if you would, please. So, what were the facts of this case then, Ben?
Well, the claimant in this case had two full-time cleaner jobs. She worked one job at a bank in London from 8 a.m. to 5 p.m. And then she worked her second job cleaning at the Houses of Parliament from 10 p.m. till 6 a.m. Both of these jobs were Monday to Friday. And she kept up this arrangement for 16 years. And the dismissal and the claims that arose out of it didn't come about because of any complaint on her part about her jobs or her working hours. What happened for the claimant, unfortunately for her, was that in 2024, one of her jobs, one at the Houses of Parliament, was TUPE transferred to her employer in the other job, Churchill Contract Services. So she now had two jobs with the same employer, and that led to that employer realising that she was working both of these contracts and working very long hours each week.
So that's an interesting story, because if she was TUPE transferred to Churchill Contract Services, they suddenly found Miss Ogamadede twice on their payroll and realised they've got two employees who happens to be the same person. And then they discovered, according to my reading of the case, Ben, that she was doing something like 77.5 hours per week, which is equivalent to 15 and a half hours a day. So astonishingly, she has the capacity to do these two jobs. What legal issues are thrown up by this situation?
Well, indeed, the tribunal noted her work ethic and the fact that she had a clean disciplinary and attendance record from both jobs. But the problem for the employer was that it was concerned about complying with the working time regulations. So firstly, all workers have a cap of a working week on average of 48 hours a week. She was working well in excess of that. Now, workers can opt out of that, and she had done so, but employers still have an overall duty of care to the health and safety of their employees. Further, there's a limit on the amount of work that a night worker can work. Somebody working at night can't work more than an average of 8 hours in any 24-hour period. And that applies to not just the night work, but any other work as well. She was clearly in breach of that. Then lastly, there's also a requirement in the working time regulations for a daily rest break, uninterrupted, so consecutive, of 11 hours a day. She wasn't getting that either. So her employer was now concerned that it would be found to be in breach of the working time regulations if the current arrangements continued.
Thanks, Ben. So what action did Churchill, her employer, take, and why?
Well, Churchill was concerned because a breach of the limits on night work can attract criminal as well as civil liability. And that's criminal liability for the company, but also in some circumstances for the directors of the company as well. So initially, they suspended the claimant from her nighttime role, that's the Houses of Parliament role, and consulted with her about changing her working arrangements so she would be complying with the working time regulations. This essentially meant working much less hours in the Parliament role that she's currently working overnight. The claimant wasn't agreeable to this, and so after the consultations didn't result in any agreement, the employer, Churchill, considered that it was left with no choice but to dismiss the claimant from her second job, the nighttime job at the Houses of Parliament, on the basis that continuing to employ her in that role would breach a statutory restriction, in this case, the restrictions in the working time regulations regarding night work. So her employer terminated that contract, but she continued to work for them in the daytime role, cleaning at the bank from 8 till 5.
So Ben, after they dismissed her, what claims did she make in the employment tribunal?
Well, she claimed unfair dismissal, and she also claimed breach of contract. So the breach of contract claim related to her being suspended for a few months without pay from the nighttime job, while the employer and employee tried to come to an arrangement that would suit both sides. Unfortunately for the claimant, the tribunal dismissed all of her claims. It found that the employer was justified in dismissing her as continuing to employ her in the nighttime cleaning job would breach the working time regulations restrictions on night work. In relation to the claim about breach of contract, the tribunal found that the claimant was trying to enforce an illegal contract, as in illegal in contravention of the working time regulations, such that she couldn't bring a claim for breach of that contract. The tribunal noted that the employer had consulted with her, offered her a revised working arrangement that wouldn't breach working time regulations before taking the decision to dismiss, such that the dismissal was within the band of reasonable responses for an employer placed in that situation.
So Ben, notwithstanding that she was unsuccessful in her claims and the employment tribunal found against her, what lessons are there for employers out there with employees with two jobs?
Well, Nick, employers have to remember that the restrictions on working hours apply across all jobs. So employers need to consider what processes they have in place to pick up whether employees have second jobs and how they're going to monitor the hours worked in that other job to ensure compliance with the working time regs overall. It's also a reminder that the limits on night working are very strict and can attract civil and potentially criminal liability as well. So employers of individuals working night work need to take more seriously the risk of those workers having other jobs on the side. It also highlights that all employees are entitled to a daily rest break of at least 11 hours between finishing one shift or one job and starting another, which in most cases should be uninterrupted.
That makes a lot of sense. It really is a health and safety measure, the working time regulations, isn't it? It's designed to stop employees overworking and not having sufficient rest, and then potentially curtailing their life because they work too hard and over many hours. So thank you for that, Ben. Really useful. I hope that you have found that to be a useful case for us to discuss, Ben and I. And if you'd like some further advice on the working time regulations and how to comply with them as far as weekly hours limits, daily rest breaks, maximum nighttime working and so on, then please do not hesitate to contact us, or indeed go to our website, www.ts-p.co.uk. Thanks for watching.